Mr. Chairman,
Yes, sir.
excuse me, one of your outstanding staff had a question in terms of the record, and if you don't mind, out of an abundance of caution, I just want to go back and make sure that we place into the record the pre-filed rebuttal testimony of Mr. James, dated October the 24th, 2018, just for purposes of on the record. I approach my witness.
Yes, please.
Chairman, I do thank your staff because they picked up a good point. Mr. James, did you prepare rebuttal testimony dated October the 24th consisting of 2 pages of testimony?
Yes, I did.
If I asked you the questions contained therein, would your answers remain the same?
Yes, they would.
Mr. Chairman, I'd like, for purposes of the record, to have his rebuttal testimony of October the 24th of Anthony James placed into the record as if given orally from the stand.
Mr. James' pre-filed rebuttal testimony dated October 24th will be entered into the record as if given orally from the stand.
Thank you. And I have one other matter. You've already placed into the record his direct testimony of August 14th, 2018 in dockets 2017, 207, 305, and 370. I do not believe that he has prepared 2 exhibits, and I would ask that the 2 exhibits, which are composite in nature, be entered into the record as the next hearing exhibit, which I now believe is 33.
They will be entered into the record as exhibit number 33.
Thank you, Mr. Chairman. You're very kind. And now I need to approach, and I made a promise on pain of death that if I didn't give these documents back, I would be in serious trouble.
You better do that then. Okay, so have Mr. James available for questions. Mr. Gile?
Good afternoon, Mr. James.
Afternoon.
We know each other, Bob Guile for Friends of the Earth and Sierra Club.
Certainly.
Let me get you please to turn to page 14 of your pre-filed direct testimony. And I direct your attention to line 17. Let me know when you have that.
I'm there.
I got that, page 14, line 17. The question, did SCE&G's concealment of the Bechtel assessment influence ORS's prudency findings? And the answer you give at line 19 is yes. I'll read. ORS believes that SCE&G's decision to conceal the Bechtel assessment, which included revised SCDs, and that's substantial completion dates?
That's correct.
For the units, meets the definition of fraud as defined in section 5833-220C. And that's the Baseload Review Act?
That's correct.
Where fraud includes, quote, concealment, omission, misrepresentation, or non-disclosure of a material fact in any proceeding or filing before the Commission or Office of Regulatory Staff. And you go on the next page to explain. Mr. James, do you stand by that testimony today?
I do.
Now, did you reach that conclusion based on your own knowledge and experience in participating, as you've described, in the oversight of SCE&G and the summer project?
Yes.
Did you also rely on the expert opinion of others, including Mr. Gary Jones, who's previously testified in this proceeding, in reaching that conclusion?
Certainly all of our NND team.
That's all the questions I have. Thank you.
Thank you.
Thank you.
Thank you very much. Frank Knapp. Mr. James, good afternoon again. Thank you very much for your testimony, your rebuttal testimony, your testimony you gave here today. We appreciate all that. Were you here when I asked a question of Mr. Jones?
Yes.
Okay. Well, then hopefully you will indulge me, because I would like to ask you the same question. You've been with ORS on this project since 2014 sometime?
I've been directly or indirectly involved with the project since the beginning in various roles. I was promoted to Director of New Nuclear Development in early 2014.
Okay, very good. So in opening comments, and I'm sure you were here, or if you weren't, maybe you heard about this, Mr. Balzer did say that, Mr. Balzer is the counsel for SC&G, said that ORS knew everything about this nuclear project. And so I think it's important that any ORS staff who's been involved or consultant involved directly respond, just very succinctly. And I know there's a lot of testimony and we can infer the answer. I can infer the answer also, but I wanted a very simple statement. So, Mr. James, did you know everything about this SC&G nuclear project prior to abandonment?
No.
Okay. To your knowledge, did ORS collectively know everything about this project prior to abandonment?
No, we did not.
Thank you very much. No more questions.
Thank you, Mr. Knapp. Anyone else for cross? Oh, sorry. Right, Mr. Kaufman.
Thank you. Good afternoon, Mr. James.
Good afternoon.
I know we haven't met. My name is John Kaufman. I represent AARP.
Good to meet you, John.
Thank you. So how long have you been with ORS?
I've been in ORS since December 2004. I was there before they opened the doors.
Great. Well, and you've been in the area of energy policy for even longer than that.
Energy policy, I was promoted to the Director of Energy Policy in sometime in 2015, where the Energy Office was moved over to the Office of Regulatory Staff as part of restructuring of state government.
Well, I have some questions just about the overlay of legal and regulatory framework with which the commission is going to have to decide this case. And you appear to be the witness who's done that primarily. And I assume that you don't have any legal training.
That's correct.
But but apparently you know your way around the state code and laws because you have extensively laid out some of the relevant provisions here.
Certainly.
So one of the primary issues, of course, is prudence. And do you believe that this is the proper place under the law and prevailing regulatory standards for this commission to determine the prudence of this entire project?
Yes, I do.
And you, on page 12 of your surrebuttal, you lay out the prudence statute, including the amendments that have been recently made. And when it says in the law that imprudent or imprudence includes but does not require a finding of negligence, carelessness, or recklessness, does that tell you, and does it tell this commission that they can find that there has been imprudence with this project, even without negligence or even recklessness? Is that?
I'm sorry. You're going to have to get me to the page.
Okay, page 12 of your September 24 surrebuttal. Oh, okay. I'm sorry.
Oh, okay.
I'm very sorry.
Well,
direct.
Okay. Well, that would help.
My mistake. Your September 24 direct.
Okay. Sure.
Page 12 and the first paragraph.
Certainly.
So the state law defines prudence as including several things, but does not require. And does that tell you that imprudence can be based on a variety of things, including the things that are listed, but perhaps other things as well?
Certainly.
And then the second paragraph defines prudence. And there it generally says that it means a high standard of caution, care, and diligence in regard to any action or decision taken by the utility. And then proceeds in several paragraphs to list things that are relevant to that. Then following on to the next page, the subparagraphs A, B, and C list specific things that that must be or can be included, but are not an all-inclusive list that the commission could consider when determining prudence. Is that fair?
That's fair.
And the first one, subparagraph A, deals with whether the utility acted in a timely manner with any passage of time which results in increased cost or expense. And that presumably is focused on whether the delay that a utility might experience might wind up costing consumers more money. That's fair reading of that. So when you look at the huge amount of testimony in this case and of evidence of how this project was managed from the onset all the way up through the shocking evidence of cover-up and the Bechtel report, do you see anything in there that would lead someone to believe that the utility might not have acted in the most timely manner with the way that it handled this project?
I think Mr. Jones touches on some of that in his testimony, where he goes into some details about the management. But once again, I think I echo his comments when we talk about going beyond our date of 3/12/2015. But there's certainly a room for debate on what occurred about timely.
And I don't mean to be critical of RS, but is it perhaps that the actions of covering up the Bechtel report were so shocking in and of themselves that they may have caused auditors to overlook maybe a growing amount of evidence of other types of imprudence?
I think covering up the Bechtel report could have caused a lot of outcomes, has caused a lot of outcomes.
And subparagraph C is where the law now refers to fraud and fraudulent acts, and that's where ORS is really hanging its hat in this case. Is that fair to say?
That seems to fit our case.
And would you not agree with me, though, that in the mountain of evidence that we've been wading through here, that there is plenty of evidence that you could perhaps put in the category of imprudence that excludes fraud, but just deals with other things that may not have reached that high level of caution and care?
I think others can go down that path. There's plenty to go through, and that could be an outcome that someone else could find. Yeah.
And would you view a finding of prudence as something that should require the commission to weigh the facts, facts that tend to show prudence and those that may tend to show imprudence, and that they should weigh a lot of other factors other than just the fraud?
Well, certainly.
All right. And there's nothing about the BLRA that eliminated the concept of prudence. In fact, prudence is in the BLRA statute. Is that right?
I'm not. The definition of prudence, there's the term of not by the imprudence of the utility that occurs throughout the BLRA. The term prudent,
right.
Yeah.
Right. So it didn't. It may have. It may have replaced somewhat the concept of use and useful, but it did not replace the concept of prudence.
That would be correct.
Right. Now I'm going to ask you about a provision of the law that is maybe so broad that you didn't think to include it in your testimony, and that's the concept of just and reasonable, and that's that's a very fundamental concept in the law of utility regulation, is it not?
Yes.
And what does just and reasonable mean to you as a regulating?
Fair treatment. That's what it means.
And is that not in Section 58 of the same law? As maybe one of the first sections, Section 58-27-810, where the Commission is instructed that every rate made, demanded, or received by an electric utility shall be just and reasonable?
I'm not looking at that, but I'm familiar with that.
And would you view the concept of just and reasonableness to be an overriding responsibility?
Certainly.
And that obligation to protect the public from unjust and unreasonable rates should be viewed as overriding all the other more particular sections of the law?
That is a statute the commission considers when setting rates.
In all of your years of working within this regulatory framework here in South Carolina, would you say that the Public Service Commission is given the responsibility of protecting the public and making sure that the actions of the utility are not resulting in an unjust and unfair and unreasonable impact on consumers?
Through just and reasonable rates.
Right. And in this state, individuals are placed in these seats up here, and not, this isn't a rubber stamp state, is it not?
It's not.
Are you very familiar with the types of regulation in other jurisdictions and other states? Have you?
Not in great detail.
With regard to the Bechtel report, based on the evidence that you've seen and that you've heard earlier in this hearing, would you say that SCE&G contracted with Bechtel or caused Bechtel to be hired early enough in this process?
Could you repeat that?
Would a prudent utility have caused an outside entity such as Bechtel to review the project at an earlier date than it did?
I believe they found themselves seeking some outside assistance around mid-2014, decided on it in the fall of 14. I think that was a good idea.
But could they have done it more swiftly than taking 19 months to actually hire them?
I don't know.
Well, if that report had been performed earlier when it was first suggested that this utility seek some outside expertise, would then that earlier date have been the cutoff that ORS chose?
Mr. Chairman, I object. Mr. James is a fact witness, and he's calling for Mr. James to make some guesses on a set of assumptions that have no foundation.
Well, this is not a legal judge. This is I'm asking about the judgment that ORS made, and my question is that, was it early enough?
Okay, I'm gonna overrule. He can answer the question if he knows the answer. If he doesn't,
I think I'll go back to we looked at a lot of information. We looked all the way back to the beginning of the project, and I think we decided that we had firm basis for our date of 3/12/2015, and there certainly is a conservative date. We probably could have made an argument going back earlier. We don't believe that would have been as strong, but certainly if others see that, there's enough there.
I would agree with you that your position is strong and conservative. Is it unreasonable for others to take the same set of facts and draw the conclusion that perhaps this project should have been canceled at an earlier date?
I'd say go for it.
All right. That's all I have. Thank you.
thank you.
Good afternoon, Mr. James. Goodwin Thompson representing the South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
Good afternoon, Ms. Thompson.
Now, there have been a lot of questions, a lot of testimony about who knew what when and who should have told the commission what when. I'm not going to ask you about any of that. I'm just going to jump ahead a little bit and talk about some of the competing plans for providing relief to SCNG's customers from this nuclear debacle. Now, you testify about the various competing plans for customer rate relief, don't you?
Yes, ma'am.
In your testimony. And the joint applicants have said they won't offer their preferred customer benefits plan unless the commission approves of the proposed merger. Isn't that right?
That's correct.
Would you agree that the proposed merger is not necessary for SCNG to offer their preferred customer benefits plan to customers?
I believe that's a condition they put in their filing. I don't know otherwise.
Based on your understanding of the company's financials, do you believe that a merger is necessary for that plan to be offered to customers?
I'd prefer not to answer financial questions. We have Mr. Lane Collin on deck here. We have multiple witnesses that can get into some of the financial outcomes.
So Mr. Collin would be the better witness to
He'd be the ideal witness.
Okay, thank you. Now, Dominion also says that if the ORS optimal plan is approved, it will not close the merger. Is that right?
That is my understanding, yes.
Now, with the exception of the merger savings that ORS witness Collin has identified, would you agree that the merger is also not necessary for SC&G to offer the ORS optimal plan?
That is correct.
Now, going back to those merger savings, Dominion has refused to even quantify, let alone guarantee, any savings to customers as a result of the proposed merger. Isn't that right?
That is correct.
Now, in your role as Director of Energy Policy for ORS, do you follow proposed utility mergers in other jurisdictions around the country?
Somewhat, if they're close by, maybe.
Now, are you familiar with guarantees of merger savings that have been offered in other proposed mergers?
I am not. Mr. Collin, once again, is very familiar with the merger savings in other jurisdictions.
Now, would you agree, though, that a guarantee of merger savings is fairly typical in a merger proceeding, is it not?
I don't know whether that is typical or not. Okay. There were merger benefits from the Duke merger here in South Carolina. There were merger savings that were essentially guaranteed.
And in the Duke Progress merger, the merger savings that would come about as a result of efficiencies and synergies, those were one of the things that the companies at the time pointed to as evidence that the merger would be in the public interest. Isn't that right?
There were certainly those components, as well as the joint dispatch of fuel savings and so forth.
Okay. Now, finally, the applicants just recently put forth an alternative plan for customer rate relief. Do you recall that? Mm-hmm. Now, would you agree that the merger is not necessarily necessary for SC&G to offer that alternative plan to its customers?
That's a question for SCE&G.
Okay. Would Mr. Collin be able to opine on that?
I'm going to go ahead and punt it to him now.
All right. Thank you, Mr. James. That's all I have. Thank you, Mr. Chairman.
Thank you, Ms. Thompson. Anyone else? Mr. Elliott.
Mr. James, do you recall Mr. Balzer telling the Commission Thursday of last week, quote, once our contractor filed bankruptcy and ORS would be taking, the Commission, I'm sure, is aware of the adage that success has many fathers, but failure is an orphan. If the project had been successful, then there's no doubt that the ORS would be taking credit for its micromanagement of the project. But since the project failed, ORS is desperately trying to remove its fingerprints. Do you recall Mr. Balzer saying that?
Yes, I do.
All right. And I'd like to draw your attention, if I may, to your testimony of just a moment ago, where you laid out the ORS responsibilities under state law to monitor the construction of these nuclear plants. Do you recall testifying to that?
Certainly. And
you recall testifying that pursuant to Code Section 58-33-270A, SCE&G is required to file reports with the ORS quarterly until the plant begins commercial operation. Do you recall testifying to that?
Yes.
And you and I will agree, I think, that SCE&G had the duty, responsibility, and obligation to file reports with the ORS, correct?
That's correct.
The statute does not require ORS to go to meetings and try to catch people in hard hats and try to frame a audit information requests just the right way to get the information. Am I correct?
You're correct.
All right. And so the Baseload Review Act requires these quarterly reports to contain certain information such as the progress of the construction of the plant, correct?
Yes.
Updated construction schedules, correct?
Correct.
Schedules of the capital cost incurred, including updates to the information required by law, correct?
Correct.
And updated schedules for the anticipated capital cost, correct?
Correct.
And last, such other information as the Office of Regulatory Staff may require, correct?
Correct.
Now, under state law, you at the ORS are able to ask audit information requests of SCE&G, correct?
Correct.
And under state law, SCE&G would have the responsibility and obligation to respond, correct?
Correct.
And can we agree that SCE&G would have the duty and obligation and responsibility to respond fully and honestly, correct?
Correct.
Now, under Section 5833-280B, revised rates filing shall include the most recent monitoring report required by law, updated to reflect information current as of the date specified in the filing. Is that Section 5833-270A?
Correct.
All right, and so again, the onus is on the company to file these monitoring reports, correct?
Correct.
Because really, the company is seeking, pursuant to 58-33-280, a rate increase on its customers, correct?
Correct.
And that statute is pretty generous to the company, isn't it?
Very.
It requires the company to file these quarterly reports, and the ORS gets a chance to audit it.
Correct.
And the ORS gets a chance to comment, correct?
Correct.
And after ORS comments, the rest of us get a chance to make a comment, correct?
That's correct.
And then the outcome is a rate increase, correct?
Correct.
And there were 9 rate increases under Section 58-33-280, correct?
Correct.
And so the logic of the statute is that to put the onus and responsibility on the company to give you a complete picture of the capital expenditures and the schedule so that they can get this real easy rate increase, correct?
True.
Now, and this may have been what Mr. Balzer was referring to in his opening argument, but you testified that under 58-33-277B, the ORS duties include ongoing monitoring of the construction of the plant and expenditure through the review and audit of the quarterly reports under this article, and shall have the right to inspect the books and records regarding the plant and the physical progress of construction upon reasonable notice to the utility. Do you recall testifying to that?
I do.
And I think I understood Mr. Jones yesterday to testify that as a part of your ongoing inspection of the project, when you would go to the plant, you'd put on this reflective vest.
Yes.
Orange?
It was yellow. With
Yellow. All right. And a big ORS sign on your back, correct?
Yes.
And you had a ORS hard hat on, correct?
That's correct.
And you had, you did have I think I got this right, the E&G issued you some kind of a badge to wear, correct?
That would be correct, a visitor's badge.
And you were, as visitors, you were able to see some parts of the nuclear plant, correct?
Correct. Escorted by SCE&G.
Okay, so the part...
We would identify where we would want to go, and they would take us there.
All right. And so that was the limited access you described, correct?
Correct.
Now, it seems to me that SCE&G had the Office of Regulatory Staff well under control when you were making these site visits. Would you agree with me, sir?
They escorted us.
I find it very difficult to see how you could be guilty of micromanaging this construction site under the circumstances that you've described. Would you agree with me?
Well, By statute, it's required that we give them notice before we can access the site. We don't have unfettered access to the site. We're not allowed to walk the site unescorted.
Well, and that makes sense. And at least until recently, you didn't have the authority to subpoena records either, did you?
Did not.
And unlike law enforcement authorities, you didn't have the authority to issue some sort of a search warrant, did you?
Did not.
You had to ask politely and get permission to go to the site, correct?
That's correct.
Now, you testify in your direct that the company's hands-off strategy delayed the implementation of the corrective measures of the Bechtel report. Do you recall that?
Not specifically.
Let me draw your attention, if I may, to page 17 of 19 in your direct testimony. And once you find that, let me direct you further to your to lines 16 through 20.
I'm there.
All right. And so, as I understand your testimony, in response to the question, did SC&G properly manage the project, you answered no. In accordance with Section 58-33-220, SCE&G's decision to take a, quote, hands-off, unquote, approach to managing the project proved to be unsuccessful and may have contributed to the project's failure. You conclude the answer by stating the company's hands-off strategy delayed the implementation of corrective measures, correct?
Yeah, I believe you were referencing Bechtel earlier, but yes.
All right. And so the corrective measures in question in this testimony are the Bechtel measures, correct?
Well, I think Mr. Jones's testimony goes into this hands-off of management style in great detail, and he ties it more toward some of the issues we saw early on with the Lake Charles facility and some of the delays we saw with the module fabrication, and maybe that SCE&G should have maybe taken a more hands-on approach to resolve some of those issues sooner.
All right, so good. So your testimony is that the history of the construction of these plants reflects a systematic neglect of the responsibilities under the contract to construct and manage the plant. Would that be a fair statement?
Could you repeat that?
Well, I think I understood your testimony to be that SC&G systematically shirked its responsibilities to manage the plant by assessing any difficulties, construction difficulties, and implementing corrective action. Is that what I understood you to say?
They identified some issues, and they did put in place corrective measures that proved in the long run not to be successful.
All right, and they delayed putting some corrective measures in also, correct?
I think that's debatable. Some would say that, once again, as Mr. Jones talks about in his testimony, responding to the issues at Lake Charles, where they ultimately de-scoped the entire facility, that maybe some of those decisions should have been made sooner. But there was always the issue, then there was always a remedy. Unfortunately, they proved to be unsuccessful.
And the company's hands-off strategy delayed the implementation of many corrective measures. That's your testimony.
Those items at Lake Charles were largely in the fixed cost price of the contract, and I believe it was SC&G's understanding that if they became too intrusive, that they would be subject to a change order from the consortium that would cause price to go up.
Well, and I was intrigued by your testimony. I went back and looked into my file, and one of the measures implemented in response to the Bechtel report was the CORB, the Construction Oversight Review Board. Do you recall that?
I am vaguely familiar with that. Mr. Jones is more familiar.
But even in your vague familiarity, you would be aware that the CORB was formed and actually began meeting in November and December of 2016. You recall that, don't you?
I do.
And by December of 2016, the CORB was really basically just rearranging the deck chairs, wasn't it?
That's a colorful description there.
Now, you also, I think, would recall that that Mr. Balzer, in his opening statement, attempted to place the blame on its partner, Santee Cooper, for its failure to complete the plans. Do you recall that?
I do.
And in response to that, I asked Mr. Jones a series of questions pertaining to the design and construction agreement between South Carolina Public Service Authority and South Carolina Electric and Gas Company, which is in the record as Exhibit 19. Do you recall that series of questions?
I do.
And I just want to direct your attention, Mr. Erskine's got this set up for me, to this contract in Exhibit B, and draw your attention to Exhibit 19, and draw your attention to 2B, top third of the page, that reads, among other SC&G responsibilities, is to manage all aspects of day-to-day design and construction of the project, including but not limited to scheduling, financial, engineering, operational, and contractual aspects of the project. Do you see that language?
I do.
And the company owed that responsibility to its partner, Santee Cooper, correct?
That's my understanding.
But also, since the ratepayers were paying for these plants through revised rates, the company owed that duty to its ratepayers, didn't it?
It did.
But the company did not finish completing these plants, did it?
It did not.
It did not fulfill its responsibilities under this contract, did it?
I don't understand the question.
Now, let me last draw your attention to your testimony of just a moment ago, where you testified, and I'm looking at your summary.
Very good.
Based on the information received by ORS through discovery, we now know the following. In September 2014, SCE&G was seeking assistance with evaluating the construction schedule and the project status, and ultimately hired Bechtel. An attorney was hired to conceal the retention of Bechtel and Bechtel's reports. And SCE&G went to extremes to prevent the release of the Bechtel report, which included a schedule analysis. Do you recall testifying to that?
Yes.
Now, I think that in your direct testimony and cross-examination by Mr. Guild, you testified that the hiding, the failure to reveal the Bechtel report, was fraud under the current statute. Do you recall that?
I do.
And so I would ask you that if you would similarly describe the conduct I just read as fraud.
Certainly the concealment of the Bechtel report seems to fit the definition of fraud.
All right. And so you did a very nice job in your direct testimony of laying out the new statutory definitions of prudence and imprudence. Do you recall that?
I do.
And you did a nice job of laying out the definition of fraud. Do you recall that?
I do.
Now, you understand that that prudence and the concept of prudence is a concept that has sort of invested rate making for many, many years. Do you understand that?
I do.
And the concept of prudence predated the statutory codification of the definitions that you describe in your testimony. Would you agree with that?
Yes, I would.
And would you agree that the concept, historically, prior to the enactment of this statute this summer, the concept of prudence implies a standard or duty of care owed to others?
Yes.
And would you also agree that in building a nuclear power plant, a utility must exercise a high standard of care in order to protect the public health and safety? You would agree with that, won't you?
Certainly.
And you would agree that while the standard to be applied is reasonableness under the circumstances, where the risk of harm to the public and ratepayer is greater, the standard of care expected from the reasonable person is higher. You agree with that, don't you?
I would.
All right. And so I think I'd just ask you this question as I conclude, and that is, would you agree with me that SC&G could no more defraud the ORS and this commission under the old law than they can under the new law?
Certainly not. When we saw SC&G's petition, which was in early January, we believe we were under the 6-month statute from petition to order. So we were working very diligently to determine what we believed to be prudent and imprudent activity. And we arrived at that date of 3/12/2015 before the law was even passed.
And so you would, your testimony is that before the enactment of the statute defining fraud as part of imprudence, that this commission could find that SC&G acted fraudulently and therefore imprudently.
I would agree with that.
Thank you. No further questions, Mr. Chairman.
Thank you. Other cross. Mr. Challey.
This is going to be fun. I only have about a day in me. I don't.
Chairman has already commented on my inability to peg time, so I make no promises, but I'll move as quickly as I can.
Certainly.
All right, Mr. James, I'm John Challey. I represent SCE&G in this case.
Sir.
Your testimony, your pre-filed testimony, discusses your understanding as to the provisions of the BLRA that you believe applicable to these proceedings. Is that right?
That's correct.
Okay. And you would agree with me that under those provisions, the provisions of the BLRA, the fact that construction has been abandoned is not, construction of the nuclear power plant has been abandoned, is not alone reason to deny recovery of costs incurred related to the project, right?
That's correct.
So the BLRA does not limit cost recovery to the circumstances when a baseload review plant is actually constructed. Isn't that right?
Say that again.
The BLRA does not limit cost recovery to the circumstances when a baseload review plant is in fact constructed.
Correct.
Right. Nor does the BLRA limit cost recovery to the circumstances when a baseload review plant is being constructed.
That's correct. Yeah.
So under certain circumstances, even when a plant is abandoned, the BLRA does allow for cost recovery, correct?
It does.
Okay. And that was a decision the General Assembly made when it passed the BLRA, isn't that right?
That is correct.
Okay. And you're not trying to suggest in your testimony or through the ORS's position in this proceeding that the Commission ignore that law, right?
I am not.
Okay. But of course, abandonment-related costs can be recovered only if those costs were prudently incurred, isn't that correct?
That's correct.
Okay. And under the BLRA, at least before it was amended this year, there was no definition of prudency in the statute, was there?
That's correct.
Okay. So the BLRA did provide that costs could be disallowed following abandonment only if the utility acted imprudently based on the information available to the utility at the time of the action in question. Isn't that right?
I believe that's the language in the statute.
So it didn't say to the utility or its contractor or its subcontractor. It said information available to the utility, and only if the utility acted imprudently, correct?
I believe that's the language in the statute.
Okay. Now, there's a new definition of prudency in the statute, isn't that right?
That's correct.
Okay. And it's this definition, this new definition of prudency, that you're relying on to justify the ORS's position in this case, isn't that right?
As I said a moment ago, we believe the date of March 12, 2015 is the date in which SC&G filed a fraudulent petition. It had nothing to do with the law at all that's passed and in place today. We believe that date was a clear sign of imprudent behavior on the utility.
But you're relying in your pre-filed testimony, you're relying exclusively on the definition of prudency that exists in the new statute, aren't you?
The new statute clarifies our decision.
Okay. But the new statute also allows for prudency to be determined in part by what a utilities contractor knows, or even what a utilities subcontractor knows, doesn't it?
I believe that's the case in the law.
And you understand that this new law was passed specifically to address the VC Summer project, right?
I believe you're dragging me down the legal road there, that I'm not an attorney.
No, Mr. James, I'm just asking for were you involved in the development of the text of the statute that was passed by the General Assembly earlier this year?
I believe I saw drafts. I don't believe I had any involvement of the text or anything like
You didn't talk to members of the General Assembly about the law as it was being evaluated?
that. I don't recall. I know we've met with members of the General Assembly.
Okay. But you are aware of the fact, are you not, that this new law was passed specifically to address the VC Summer project?
I believe it was.
Mr. Chairman, I'm going to object to that line of questioning. That's a legal conclusion for the commission to determine.
And I rise for the. Sorry. Mr. Chairman.
We're going to sustain
Steve
that. Yes.
I rise to make the same objection. He's asking this witness to infer what the General Assembly intended, and that involves surmise, conjecture, and speculation, which our Supreme Court has specifically ruled cannot be part of a decision.
Thank you. I'm going to sustain that, and we need to move to the next question.
Okay. Mr. James, you are aware that the ORS has broad statutory powers and authority to regulate utilities in South Carolina, isn't that right?
Yes.
And the duties include giving information to the commission, whatever information and reports as may reasonably be required to supervise and control the public utilities operating in South Carolina. Isn't that right?
I'm not familiar with the statute that you're reading from, if that's something you could show to me.
Yep, we'll put it up on the screen. This is slide 1 of what we've working with, Dan. Thank you. So this is section 58.450B. Makes clear that the Office of Regulatory Staff commands, it says must employ the resources of the regulatory staff to furnish to the Commission or its members such information and reports or conduct such investigations and provide other assistance as may reasonably be required in order to supervise and control the public utilities of the state.
Certainly. I agree with that. Yeah.
So the ORS must employ the resources of the staff to provide information required for the Commission. Correct?
My understanding of that statute is when ORS was created, the responsibility for performing investigations were removed from the Public Service Commission and moved over to the Office of Regulatory Staff.
That's right. So under the law that exists, the ORS has the responsibility for conducting investigations, conducting audits, and collecting information. Isn't that right?
That's correct.
Okay. And so that's actually codified in section 58.450A2, which is slide 3, Dan. It says it is the duty and responsibility of the regulatory staff to make inspections, audits, and examinations of public utilities regarding matters within the jurisdiction of the Commission. Right?
Fair enough. Yeah.
And it then concludes the regulatory staff has sole responsibility for this duty.
Sure.
Okay. And then beyond that, beyond the sole responsibility, if the Commission requests the ORS to do so, the ORS shall also make such inspections, audits, or examinations of public utilities as requested. Isn't that right?
They have, and we've done that, yes.
Okay. So the ORS's function is not merely to monitor. The ORS's function is to make inspections, audits, examinations, and furnish information to the Commission as reasonably as necessary to regulate public utilities. Isn't that right?
I think you might be expanding overall.
Object. He's asking a non-lawyer. He can ask him.
Hold that microphone up close to you, Mr. Hams.
I don't think I can get it any closer.
Well, you're going to have to lean then. You had it close to the last time. Keep it. You were good the last time you were talking, just when you started.
All right.
You're good. There you go.
Good for me. My objection, Your Honor, is that counsel can ask about the language in the statute, but he's attempting to elicit a response about how to construct the statute, number one. And number two, I would note he's talking about a different statute that deals with the obligations under the Base Load Review Act. So I think he's attempting to, well, I'm not sure what he's attempting to do, but he's certainly not asking about the specific responsibilities enumerated in the Base Load Review Act. And he is certainly available to ask, well, is that what it reads in plain English? Yes. Further than that, I think he's attempting to elicit a legal opinion, which I believe is improper, and I would ask that he be directed to cease such questioning.
Sustained, and we'll move on.
Okay, the last thing I want to ask you, Mr. James, and to be clear, I'm not at all seeking for your legal opinion. I just want to make sure I understand what you understand the ORS's duties to be. But you would agree with me that the ORS, in carrying out the duties that we just described, has the ability to require the production of books and records and other information it believes necessary, right?
I think I draw you back to what I put in my testimony, where the Baseload Review Act clearly outlines what ORS's responsibilities are within the review and the review and monitoring of the construction and schedule.
So is it your testimony that it is your understanding in your role with the Office of Regulatory Staff that the Office of Regulatory Staff doesn't have the ability to require the production of books, records, and information that the regulatory staff believes is appropriate?
I'm getting confused. I think you're conflating two different ideas here. My response is that when the Baseload Review Act was passed, I mean, if you read the way it's structured, when it came to us, our understanding was that it was supposed to be almost entirely an administrative process. It was SC&G was to submit quarterly reports, and our ongoing monitoring was just the review of those quarterly reports. And the revised rates, it's an administrative process as well.
Well, that's not what the ORS actually did, though, because the ORS issued various audit information requests, didn't it?
And I'm going to agree with you, because we found ourselves primarily in 2014, when I was promoted to the director of new nuclear development, that we're going to push the edges because we needed more information. I think our overall strategy, we're going to ask what we ask to get the information we need. And if SC&G says no, they'll have reasonable grounds to deny it because of the law. It's certainly written that way. Our approach is that we're just going to beg for forgiveness.
Did SC&G provide information in response to audit information requests?
SC&G was very forthcoming and very responsive to a lot of our requests. The Bechtel report is just what drops our jaw. We never knew anything about it.
Okay, well, Mr. James, you did you sit through Mr. Jones's testimony from Friday and Monday?
I certainly did.
Okay, so you're aware that it is not at all accurate to say the ORS knew nothing about the Bechtel assessment?
Well, what I would say is that we knew something was going on. We didn't know anything about 10 senior Bechtel guys interviewing top to bottom staff related to the project, doing a full-blown schedule analysis of the project. What we knew was that, SC&G was hiding something.
Did you?
And what we did know is that whatever they were hiding was somehow related to Bechtel. I think that is really the extent of what we knew.
Okay, you characterized the Bechtel schedule assessment as a full-blown schedule analysis. I just want to make sure we're clear on this. You indicated that you reviewed the deposition of Ty Troutman, did you not?
I did.
And you do recall during Ty Troutman's deposition when he said that Bechtel didn't even download the full amount of the schedule that Westinghouse and CV&I had prepared. Isn't that right?
My response would be that Mr. Troutman, time and time again, he said they got everything they needed. They did a level 2 assessment of the project, and that was enough information to give them some good dates on where that project was heading.
A level 2 analysis that took 10 people, total of less than 8 weeks, as compared to dozens and dozens of schedulers of Westinghouse spending countless hours over many years to develop a baseline schedule.
Well, Mr.
Troutman
right? Says he stands by that schedule, and all I would say is that if they didn't believe it, they should have still showed it to us and said, we don't believe this. I don't understand why they hid it from us.
Okay, and then last question on this. You also recall, because you testified as to some of the reports, you recall in the Bechtel reports that Bechtel itself said that further analysis and development is necessary to justify a rebaselining of the schedule. Do you not?
I believe that to be the case, but once again, we were robbed of the opportunity to even get any of that information.
Okay. Well, you weren't robbed of the opportunity to get any of that information. We've already discussed that with Mr. Jones. But I do...
Mr. Chairman, I'm going to have to object to the characterization he just made. I don't believe that reflected the testimony of Mr. Jones. That was an editorial on the part of counsel, and I object to the form of the question.
Sustained.
Okay. Mr. James, we have talked a lot about Bechtel. Would you agree with me that Mr. Gary Jones and Mr. Gene Solt were the ORS eyes and ears as it relates to the project?
I would agree.
Okay, so what they knew about the project and what they knew about Bechtel is ultimately what the ORS knew about those things. Isn't that right?
That's fair.
Okay, is it, what I'm trying to make clear, just to sort of move things along a little bit, is that you don't have independent information to provide the commission as to ORS's knowledge about Bechtel, right?
No, well, once again, I've been doing this for a long time now with ORS, and I've been involved with SCE&G for almost the 15 years that we've been in have our doors open. We meet with SCE&G all the time, and it's just not nuclear work. It's fuel. It's siting. It's rate cases. We have I thought we had a close relationship with SCE&G, and I still think we do. What I was wondering is how do we not know about the Bechtel assessment? My expectation would have been that I would have gotten a call from someone in middle management from SCE&G say, hey, Anthony, we're going to do an assessment. Bechtel's going to come in. We're going to do an assessment. We're not sure what it's going to say, but we want you to know that that's what we're going to do. Very early on in the project, where I was promoted, I made that request of many folks at the site, was just let ORS know the good, the bad, and the ugly. I mean,
and again, you do recall that the record has already established, in part through ORS's interrogatory responses.
Chairman, I'm conscious of the time, but this commission has always had the practice of allowing a witness to complete their answer, and perhaps inadvertently, counsel did not allow the witness to do that.
Please.
Okay, absolutely, yes.
Well, and once again, I've been before this commission many times, and I believe that we work with SCE&G closely. ORS has been in support of those nuclear units from the very beginning. We thought we had signed everything that there was to sign to get access to all the information that we needed to get. So this was highly unusual, very uncharacteristic in my work with SCE&G, for them to do something of this level, of this significance, and we know absolutely nothing about it. Finding out about the Bechtel report through work of the General Assembly, it just dropped our jaw. We don't understand it. I continue to struggle with it.
Okay, thank you, Mr. James. What I want to make clear is what I believe the record has established, in part through ORS's interrogatory responses. But let's just go down the list, the timeline. You're aware, are you not, that Bechtel was engaged by an outside law firm in August of 2015?
That's correct. Yeah.
And you're aware, are you not, because it's admitted in ORS's interrogatory responses, that in August of 2015, Gene Solt was informed that the legal department at SCANA had engaged an outside consultant to conduct an assessment of the project?
Well, I think that's what the record shows. If you were to depose Mr. Solt, and I believe his response is similar to mine. We had no idea this level of assessment was going on behind our backs.
But then the record further establishes that in October, Mr. Solt participated in a Plan of the Day meeting where a Bechtel employee thanked everyone for their assistance in the assessment, donned a Bechtel hard hat, discussed issues related to productivity, and as I said, thanked everyone for their assistance in the assessment. Isn't that right?
And I believe that's what the record may show there. And I believe Mr. Solt, I believe he came back to our team and said, Bechtel is on site. What the heck are they doing? I don't know. So let's start asking. And we asked a lot.
Well,
And
Mr.
we
Jones
still
asked.
did not know. Yeah.
Sorry, go
Yeah,
ahead.
we asked a lot, and I think the answers were mumbled responses that seemingly led us to believe that there was no significance to it. But once again, I don't know how they didn't come forward with all of this information.
So Mr. Jones asked in October, shortly after this Plan of the Day meeting, he included an agenda item on the monthly site visit. Please discuss the top 10 lessons learned from the Bechtel assessment.
Yeah,
Recall that?
Yeah, we do chuckle about it now because it was a shot in the dark. I mean, we're efficient.
Right. And the response that Mr. Jones got was that Bechtel had learned nothing new from the assessment.
That's what he said.
And that's consistent with the testimony that you saw presented on the screen earlier today from Mr. Ron Jones, from Mr. Kevin Marsh, from Mr. George Winnick, who's a lawyer who actually engaged Bechtel, isn't it?
And I believe Mr. Jones' testimony is that we had no idea there'd be 10 high-level nuclear experts walking around the site doing a top-to-bottom assessment of the project. We should have known about that. I don't know how we did not know.
You did know that an assessment was being done, and other than AIR 132, we can't identify a single instance where the ORS sought additional information, right?
Well, it's providing the oversight there. I can tell you the only thing we did know, and I said this earlier, we knew something was going on. We weren't sure. We knew they were hiding something, and we knew it had to do with Bechtel.
And you didn't issue an audit information request until May of 2018 that said it even used the word Bechtel.
Well, once again, as soon as Mr. Solt found out about it, we added it to our agenda item, and it was as we trusted SC&G. They said there's nothing there, and that was the nature of our relationship. Is that if they said there was nothing there, there was nothing there.
Okay. Now you also heard testimony from Mr. Jones related to the estimate at completion, didn't you? He discussed this idea of
sure.
estimate at completion.
Sure, certainly.
And I think you correct me if you heard something differently than I did, but as I understood Mr. Jones, he was saying that when SCE&G understood that there were certain concerns regarding Westinghouse's 2014 EAC, SCE&G should have negotiated further with Westinghouse regarding that EAC. Did you hear that?
I did hear that.
Okay.
I don't know that necessarily I agree entirely with that. My position was that if we had known that SCE&G was doing their own assessment, because they clearly didn't believe the consortium numbers themselves, they put a team together to go do their own assessment. And all I would ask when I was out at the site is just tell us all the information. If you say we've done our own assessment and it's $1.2 billion, Anthony, it's not $698 million, then we decide where to go from there. But we didn't get an opportunity to even get any of that information. It was hidden from us. And specifically when we had the meeting out at the site to try to figure out why there was so much discrepancy about the numbers, that's when we find out the man that knew the answer, Mr. Ken Brown, he was intercepted and given talking points.
You did see Mr. Ken Brown's testimony where he said he clearly conveyed inaccurately and completely the circumstances surrounding the 2015 EAC information.
I understood the Ray Charles statement, but yeah, he said I laid enough breadcrumbs for them to follow. But we don't have to pick up breadcrumbs. They should tell us.
Well, they did tell you.
They did.
You knew what the historical productivity factor was. You knew what the assumed productivity was by Westinghouse. You knew, the ORS knew, that Westinghouse had been unable to achieve the promised productivity factor within the time that they had committed to. You knew all of that, didn't you?
What we did not know.
Mr. Chairman.
Put it up close, Mr. Ham. There you go.
Mr. Chairman, I know time is at play here, and we have taken some pride that we have tried not to restrain this proceeding by many objections, and I think you'll reflect we haven't raised any. But I think what we've gotten on, I believe what is going on here and ask for a ruling is essentially trying to piece together counsel's own view of the evidence, and he leaves out material facts in some of his questions. For example, Mr. Jones testified that he was told there was nothing in writing. Now, he's piecing together his best view. I view this as the smokescreen defense, where they put out enough stuff and we're supposed to hanker around in the smoke and figure out what's going on. My objection is he is predicating his questions in a way that is not consistent with the sworn testimony heard by this commission, and he is attempting to elicit a response where he's not positing the underlying facts now in front of the commission. So I object.
Let me have a response from Mr. Jolly.
Yes, I'm simply trying to move things along as quickly as I can. I walked through with Mr. Jones in quite in some detail the circumstances related to Bechtel and EAC, and I had no intention of taking the Commission's time in much the same way with Mr. James. But there are some critical facts that I believe were established, and in fact are established by ORS's own interrogatory responses. So I'm just trying to make sure I understand the full extent of Mr. James' testimony on those points.
Mr. Chairman, this commission is the finder of the fact, not SC&G, to characterize what has been established by the record to date. This is counsel testifying, and it is improper. This commission is the one who ultimately determine what facts are found by the testimony. If he wants to elicit a question, ask a question, and elicit a response, allow you to find those facts at a later time, that's appropriate. But this is certainly an inappropriate line of questioning.
Okay, what we're going to do is we need for you to rephrase your question and try again. And
yeah, thank you. Let me just see if I can move on here. Mr. James, what I want to go back to is, as it relates to the Bechtel assessment, I want to make sure we're absolutely clear that you have no independent information related to the Bechtel assessment beyond what Mr. Gary Jones has testified to or what Mr. Gene Solt has testified to in this proceeding. Isn't that right?
And when you say independent, I
mean separate from what they know and testified.
That would be true.
Okay.
As acknowledging Bechtel on the site, I'm a little lost on the question there.
Yeah, the only point is if their testimony as to what they knew or did not know related to Bechtel is you have no additional information regarding what ORS did or did not know relating to Bechtel.
Fair. That's fair.
Okay. Now, I was asking you a couple questions about the estimate at completion.
Sure.
And I described to Mr. Jones as suggesting that at the time, if SCE&G had determined there were concerns with Westinghouse's estimate at completion, Mr. Jones said, well, you should have negotiated with Westinghouse. You said you don't know that you agree with that. Is that right?
That is an approach you could take, and I believe that was SCE&G's intent. But that's how you ended up with the 2015 case where you had about $500 million of disputed and delay-related costs that were unresolved.
Well, let's just be clear about that. So you understood, at least from the way Mr. Jones has characterized and others have characterized the SCANA EAC team's work, we'll use that phrase, that EAC team was suggesting the estimate at completion would be substantially higher than what Westinghouse had suggested. Isn't that right?
That's correct.
Okay. So what I understood Mr. Jones to be suggesting, you tell me if I'm wrong, based on your understanding, was that SCE&G should go to the consortium and negotiate for a higher cost to construct the project. Is that right?
I heard him say negotiate. That doesn't necessarily mean you're negotiating for a higher cost. You're probably trying to find some middle ground to resolve those issues that are in dispute.
And ultimately what SCE&G did is say, consortium, you committed to a number, I'm holding you to that number. That's the lowest cost available, wouldn't it? In the scenarios we've talked about. Mr. Jones, go with the internal SCE&G's estimate of completion. Your negotiate final middle ground. Those are both higher than what ultimately happened, was that SCE&G went to the consortium and said, we're sticking to your estimate based on a 1.15 productivity factor, and that's all we're going to ask the commission for, right?
That is exactly what they did. My issue is that we did not know that SCE&G had a team that did such a an in-depth analysis of their own, and it turned out to be $1.2 billion. It was a higher number, but at that time, all we could review were numbers that the consortium had given SC&G, and we don't regulate Westinghouse, we don't regulate CB&I, so we can't issue them data requests. But certainly, if we had numbers, we had seen SC&G's numbers, more than likely we would have been able to issue them data requests to determine the value of their numbers. And we would likely brought both numbers to the commission if we couldn't figure out where to go. But just not having all the information is the problem. We should have had all of the information to make our decisions.
Mr. James, you met with the consortium to discuss issues related to the estimated completion, didn't you?
I did not, no.
Well, the ORS did they not?
The only meetings I know dealing with the EAC were SCE&G representatives out at the site.
Okay. Well, you issued audit information requests related to the EAC and got a copy of the presentation that Westinghouse had provided to the owners related to their 2014 EAC, correct?
We did not issue data requests to Westinghouse or CB&I to get support for the numbers they developed.
I understand, but you did issue data information requests to SCE&G, and SCE&G provided you with the information they received from the consortium regarding the 2014 estimated completion, correct?
Yes, and as we sat across the table from SCE&G and had questions about those numbers, they said, it's just what the consortium gave us. That's what we have.
That's right. And then you actually issued an audit information request to elicit more information as to why SCE&G believed the 1.15 productivity factor was accurate, correct?
Yes.
And SCE&G provided that information in response to that request and said we have had frank discussions with the consortium regarding this productivity, but that under the circumstances we see no reason not to require the consortium to meet their promised productivity factors. Isn't that right?
That's all well taken, but not disclosing the work of the EAC team to us, it's just unexcusable.
And that's the EAC team that you believe was led in part by Ken Brown.
We knew Ken Brown. When we could not get comfortable with the numbers out at the site, we asked, who did the consortium give the numbers to? And then we learned that, there's a Mr. Ken Brown and there's a Mr. Kevin Cocombs that are familiar with it, and there's some others that are familiar with it. And we just shook our head and wondered why we were spending so much time talking to the folks that didn't have the best information. But we did learn. And we did establish a meeting we want to talk to Mr. Ken Brown. We want to talk to Mr. Kevin Cocombs and schedule a meeting. We scheduled the meeting, and now we learn before that meeting, Mr. Ken Brown was intercepted and given talking points and told what to tell ORS. And it excluded that he had no confidence in those numbers that they were presenting to us to give to the commission.
And Mr. James, you also saw, as we talked about earlier, you saw the testimony that I flashed on the screen earlier today, where Mr. Ken Brown, despite all of what you just said, indicated that he believed he provided true, accurate, and complete information to the ORS in the very meeting that you're talking about.
And I don't understand the entire context because other parts of his deposition conflict with that.
Well, it was unequivocal in the language that you saw earlier today, right?
The language in my testimony shows that he was given talking points, and those talking points didn't include that he could tell us he didn't believe those costs they were providing to us were attainable.
Okay. But his testimony, the testimony that I flashed on the screen,
I saw it.
said clear.
Mr. Chairman, we're now getting to the point of being argumentative. He's given his answer several times. Counsel's not particularly happy with the answer and is trying again and again. And you, Mr. Chairman, and your hearing officer have repeatedly reminded all of us to avoid that kind of conduct, and it's taking place right now.
And that's sustained. We need to move on from this. We've asked that same question over and over.
Okay.
So let's move ahead.
I have no more questions.
Thank you. Okay. Next, We'll hear questions from the commissioners, and we'll hear from them at 9 o'clock tomorrow morning. We are adjourned.